me, and I'll be able to be assisted in that regard.
Mr. Chair.
The Honourable Craig Foss.
Thank you, Mr. Chair, and I do acknowledge that this bill has been in gestation for quite some time, and members have acknowledged it was introduced by the previous Labor government and the previous Minister of Commerce. I guess, in defence, Mr. Chairman, I guess this new Commerce Minister is making good progress, only having this bill for 6 months, but here we go. A few points that have been raised by members, Mr. Chair. And the member has done well to find that on her iPhone. And, Mr. Chair, there are safeguards in place for the use of information gathering powers in the Act, and of course there is a judicial review available in reference to this, and I'll go through some of this in a bit more detail in a moment. And of course there are existing incentives on the Commission to protect the confidential information received and the leniency provisions, as this is standard practice and around this future supply of information. Let me explain it a bit further, Mr. Chair, because others have raised similar issues. The cooperation arrangements, which members have started asking questions on, most of those were set out in Subpart 1, Clause 6, Sections 99D, etc., for the various parts of the different acts where this eventually, with the permission of the House, will get split out too. Mr. Chairman, but the Commission can only assist overseas regulators in the first instance with its statutory powers or through passing on compulsorily acquired information if a government-to-government cooperation arrangement is already in place. This ensures reciprocity of the intent from the start. So, as I said in my earlier speech, the hard work here is done up front. The rules, the terms and conditions of the pre-existing arrangement for government-to-government or the regulator thereafter to share information. And before entering into a cooperation arrangement, the responsible minister must take into consideration public interest matters such as the legal framework of the overseas jurisdiction and the potential consequences for New Zealand businesses and consumers of the proposed arrangement. The minister must also consult with the Privacy Commission on any privacy issues. The content of the arrangement must be set out as to how any compulsorily acquired information may be used and kept secure. To provide transparency, cooperation arrangements must be gazetted and a copy should be posted on the Commission's website. So I hope that provides a little bit of information, Mr. Chair, to those that are concerned about some of those issues. A member, Mr. Williams, earlier had concerns about sometimes requests may be deferred or asked of the Ministry of Foreign Affairs, and he shared with us some of his thoughts about those issues. I'd just like to point out that came from a recommendation from the Select Committee process, but it's fair enough that he brought the issue up. And just let me highlight, Mr. Chair, that the Select Committee recommended changes to require the Commission to be satisfied that the provision of assistance under the bill will not prejudice New Zealand's international trade interests. If, after consultation with the Ministry of Foreign Affairs and Trade, the Commission considers a request for assistance or information has significant trade consequences for New Zealand, then the Commission must refer the matter to the Minister of Trade. The Minister of Trade then decides whether the request for assistance should be accepted. Mr. Chair, so hopefully that alleviates some of the concerns that the previous speaker, member a few speeches ago rose. There's also some questions being asked about protecting of privileged information, and just quickly, Mr. Chair, to encourage sharing of privileged information, the bill strengthens its protection. It does this by providing that information that is privileged in the hands of the Commission will continue to be privileged, even if the Commission provides the information to an overseas regulator. Also, if privileged information is received from an overseas regulator, it remains privileged in New Zealand. To protect information provided in confidence to the Commission in relation to settlement negotiations, this will not be able to be provided to overseas regulators without the consent of the parties. So, Mr. Chair, I acknowledge that the concerns and the issues that submitters obviously rose and are fair enough if the member can't remember if they appeared or was written, I don't know either. But again, the intent about the sharing and the intent of this bill and the good consideration that the committee in this House are giving to it should ensure and alleviate those concerns around the House. Mr Chair.
I'm calling Dr David Clark.
Thank you, Mr Chair.